our proposal is the Law Commission should look in the light of various family law reforms that have taken place since we first signed up to the UNCRC, to see how our domestic law is now measuring against the requirements put down by the obligations internationally. Now, the idea for the proposal came from research that Jan and myself have been doing, where we have been looking at the way children's voices are or quite often are not heard, particularly in out-of-court dispute resolution processes when parents separate. Now, we then realised that these concerns about the lack of children's voice have also been echoed in the in-court context as well. So in the reports that have been done by the Private Family Law Working Group and presented to the President of the Family Division, both the Family Solutions Group report, What About Me, which has been focused on out-of-court dispute resolution, and the so-called harm report, which is looking at how children's voices, particularly in the context of abuse that's ongoing within families, and whether children who wish to refuse contact with a parent are actually heard, have been put forward as something that really does need to look at it. So our focus today is therefore on private family law disputes and whether in this context facilitating the rights of children may have got left behind, partly in the push to try and encourage out-of-court settlement between parents, so that the focus has very much been switched to the adults rather than on the children. And this, of course, then raises the question of what this means for our international obligations under the UNCRC. And we suggest that this situation raises not only issues of access to justice for children, but also of consideration of the effects of substantive law developments, and whether, in the light of that, the way that children's rights can be overlooked when other aspects of family law or family justice reforms need to be better embedded in our family justice system to ensure that we do not end up in breach of our international obligations. And who better than the Law Commission to take on this important challenge? So what does Article 12 of the UNCRC say, first of all? So as you can see on the slide, and I'm sure most of you will know, that it assures a child who's capable of forming his or her own views the right to express those views freely in all matters affecting the child, the views of the child being given due weight in accordance with the age and maturity of the child. And what that means in practice, how that's been interpreted, is that children should be both informed, consulted, and where necessary, represented. And of course, in our domestic law, the Children Act 1989 is the main means through which UNCRC rights have been given. And indeed, both the UNCRC and the Children Act of 1989 were introduced in 1991. It was rather assumed at the time, some 30 years ago now, of course, that this was an act, a really well-regarded act that has in many ways stood the test of time and is still heralded as an important way in which we codified child law, whether this does still protect particularly the Article 12 rights. So if we go to the next slide, we can see how perhaps there is some question marks being raised on how well this is done. Now, the Children Act, of course, focuses on children's welfare. There's not a mention of children's rights in the Act. And it's the paramountcy principle which gives protection to children where their best interests must prevail in matters concerning the upbringing of a child. But of course, Section 1.1 only applies in court proceedings. And whilst in the checklist in Section 1.3 of the Children Act, the ascertainable wishes and feelings of the child are listed as a factor, it's not a priority factor, and it's just one of a whole range of matters that have to be taken into account and in deciding how to apply the welfare principle. Now, I think that we probably wouldn't want to argue that Article 3 of the UNCRC, which does indicate that children's welfare must be taken into account, is well safeguarded by Section 1.1. But I'm far less sure that Article 12 is met in this context. And if you think back to the era when this 1989 Act was passed, even Lady Hale, who of course as a law commissioner then led the Children Act reform, admitted in her 2019 Scarman lecture that looking back, although we were aware of the European Convention on Human Rights, it played a remarkably small part in our thinking. And I think this sort of underlines that at that time, human rights thinking was not embedded in the DNA, if you like, of family law domestically. And I think that's particularly true and probably still true today with regard to the position of children's rights. Now, the other problem, if you like, with the Children Act is that has itself been reformed. And Section 2A there is, of course, the fairly recent introduction of a statutory presumption of the benefits of both parents' involvement in a child's life after parental separation. And you might think that would therefore require some sort of check with the child that this contact with both parents in any child arrangements order is something that the child themselves welcomes. After all, they should be informed and they should be consulted and, if necessary, represented under Article 12. That really is not the position. If the matter goes to court and a Section 7 report is ordered, then the children's views do get to court. But even in court proceedings, although safeguarding checks do happen, it's not always true to say. In fact, the harm report says it's not often enough the case that children's views do actually reach the court. You combine that situation post-LASPO, which of course withdrew legal aid from private family law proceedings for child arrangements. If you combine that with the fact that most cases are being encouraged to be heard out of court through mediation or direct negotiation between the parents, and children are not necessarily informed or consulted at all about the arrangements. Indeed, the research that Jan and I have done in relation to the mapping paths to family justice research, and later research where we've been speaking to children directly, indicates that whilst they very much welcome to be involved, they were often not told. And parents often say, well, we didn't tell the children until the night before or the week before I moved out what the arrangements were going to be, which of course then questions what effect that sort of a shock might have on children in those types of circumstances. So in previous times, Section 41 of the Matrimonial Causes Act also required the court, whenever parents got divorced, to have oversight of whether the arrangements made for children were satisfactory. That no longer applies, so we don't have any way for to really make sure that even the Children Act welfare threshold is being met by the arrangements that are being discussed between the parents. There's just an assumption that the autonomy, the private ordering will work in children's best interests. And whilst in the majority of cases that will probably be the case, that the fact that children do not have a voice in any of this, in a matter that so directly affects their lives, I think really begs the question of how well our law is serving children, and whether we ought to think about recasting, either through the Children Act or otherwise, an emphasis on children's rights. Next slide, please, Jan. So if you click through, Jan, to the different quotes here, the position in and out of court, I think, is encapsulated quite well by some of the quotes here. So James Munby, the former president of the Family Division, talks in the top left-hand corner there of how, by and large, children are completely invisible in court, which I think is a real indictment that despite the welfare, their welfare being paramount, they really don't have a voice. Similarly, the harm report indicates that there's a lack of consultation, and children are muted in various ways, with the pro-contact culture introduced by Section 2, capital A of the Act, meaning that children are only heard when they wish to have contact, not when they don't wish to have contact. And Helen Stalford and Catherine Hollingsworth quote there really indicates how children are represented by proxy adult filtered accounts, and is that good enough when they have rights under Article 12 of UNCRC? And as mentioned, our own research has found that despite lip service being paid to the importance of being child focused in out of court processes, it was difficult to retain that focus. Next slide, please, Jan. Now the quotes here are from a recent and ongoing project about child inclusive mediation. And the good news is that we do have agreement, both between young people and relationship experts, that if we were to reform the law to give children greater voice, it would definitely serve the interests of children well in terms of their health and well-being, and perhaps particularly their mental health. Johnny, a young person that we interviewed in our project, said it's their family too. They should have a right to make the decisions about how it's going to move forward, echoing the right to express their views in Article 12, the right to be informed and consulted. And Kay Eagles, a relationship expert, really just talks of the benefits to young people of going down this route. So whilst we didn't find that children, I mean, these quotes typify our findings amongst a wider pool of people. And the vast majority of children, I think we only had two children from the same family where a father had not listened at all to their view, that felt that child inclusive mediation had been pretty much a waste of time. But generally the positives felt by children just by being able to express their views came through loud and clear. And it went far beyond the simple settling of the dispute at hand. Children don't categorize this in terms of their rights, and they don't really have any awareness that they have any rights. I mean, it's clearly a well-kept adult secret. But on principle and without exception, they felt children should have the right to be involved when they wished to. So if we went down this route, what would we achieve? Well, I think it would certainly improve things for children. And if you go beyond the period of separation, often things agreed are set in stone. And children have very limited ways of challenging the arrangements that the parents have agreed. Although under Section 10 of the Children Act, you theoretically can apply for an order if they get leave of the court, there are enormous practical barriers to doing this. So we suggest a duty to consult on arrangements could be enshrined in the Children Act, whether the arrangements were being agreed in or out of court. And that would be a simple way of changing the dynamics. The harm report also indicates that if you hear from children, this can actually lead to the facilitation of agreements. So I think it could act to reduce conflict in that way as well. And it unpicks whether allegations made between parents do or don't have merit from the child's point of view. And it would also help us meet our international obligations, where the UK does have to report on measures being undertaken to bring domestic legislation in line with the UNCRC, with the next report being due, I think it's March next year. So this would be a great opportunity. Jan, could we have the slides there? So we think the Law Commission could scope this out, see how well current law protects children's welfare in child arrangements, both in and out of court, and consider whether we could amend the Children Act itself to perhaps go beyond court proceedings, to include any attempt to make arrangements for children out of court, where mediation is, for example, still legally aided, and to ensure that there is a reality to ascertaining children's wishes and feelings about arrangements affecting them, to check whether there's a need for a welfare threshold, so that although parents are free to agree arrangements, the lack of oversight means that in essence nobody's checking on that unless they end up in public law proceedings as a result of significant harm suffered by a child. And why not, within the Act, give the child the right to be informed, consulted, and if necessary, represented. Next slide, Jan, if you just click through. We think this is timely, because we have moved everything out of court as far as possible, but that should not be to a situation where children have little or no agency without the law taking stock of the implications of this. We do need to ensure that we're not pushing children, in effect, into public law proceedings where they are exposed to significant harm, because we are not checking that the arrangements for them made between parents are satisfactory. And there is a move, including by Wales and Scotland, to promote the rights of children by including UNCRC rights within domestic law. And indeed, we are due to report through the 4 Children's Commissioners of the UK as to how we are measuring up to that. And we think it would be a very good idea if in England, where no developments have yet taken place, we are at least scoping out how well the current law does measure up to Article 12 requirements. Otherwise, there is a move, as I say, in Scotland and indeed already in Wales towards adopting a children's rights framework in other parts of the UK. And do we really want to leave the children of England and indeed Northern Ireland behind? So I think it's an absolutely critical moment to think about this now. Final slide, Jan. So, as I say, good moment. The Law Commission are entirely ideally placed to do this. And I have focused here with Jan on what the private law situation is, but there would be no reason why perhaps we shouldn't look at this from a public law point of view as well. And I think, you know, there is research, Lundy and others have indicated that actually if you do go as far as incorporating the UNCRC into domestic law, the signs are that it provides a platform from which other legal measures that give children enfranchisement, if you like, and positive consequences do follow automatically. So thank you for listening, and that's our proposal.